Harvard Bookstore, I'm happy to welcome you to tonight's event with Professor Laurence Tribe, who is here to discuss his new book, Uncertain Justice, The Roberts Court and the Constitution. Laurence Tribe is the Carl M. Loeb University Professor at Harvard, and he's been teaching at Harvard Law School for 4 decades, where he has been recognized both by the university and by his students as one of its top professors. He specializes in constitutional law and has argued dozens of cases at the Supreme Court, including the first argument in Bush v. Gore. In addition to his extensive writing about the law, which includes his treatise, American Constitutional Law, the most widely cited legal document since 1950, he has helped to write the constitutions of countries like South Africa, the Czech Republic, and the Marshall Islands. For many of us, the judiciary and the Supreme Court at its head is the most remote of our 3 branches of government. But from voting rights to marriage equality to health care, the decisions of the Roberts Court have a major impact on American life. In his new book, Uncertain Justice, Professor Tribe takes an in-depth look at today's Supreme Court and how it is revising the way the Constitution is interpreted. Uncertain Justice explores how in our time of cultural, social, and technological change, the decisions of the Roberts Court will have a lasting impact on America. Please join me in welcoming Professor Laurence Tribe.
One of the research assistants, and I should say thank you all for coming here on this gorgeous day when you could be outside enjoying the weather. I'm glad that something drove you all here, and I'm glad to be talking to you, and I'm appreciative of your being here. One of the research assistants working with me this summer, a terrific kid named Max, went home to New Hampshire in late spring and spent some time talking with his high school music teacher. She knew that he went to Harvard Law School but didn't know that he was working with me, and she kind of unloaded on him about her great disillusionment with the Supreme Court. She'd been looking at the headlines about how partisan the divisions seemed to be. A lot of the people whose journalism she respects, people like Linda Greenhouse, were saying, really, this is a very partisan, very polarized court. Why aren't they just a bunch of politicians in robes? Why should I trust these guys? And my student tried to reassure her that it's not really as bad as all that. She wasn't convinced. She told him she had listened to the confirmation hearings when John Roberts, who was going to become Chief Justice, made an analogy to umpires. Now, she was a baseball fan, and she didn't find the analogy very persuasive. She said that the new Chief Justice says he's only going to be an umpire calling balls and strikes. It's all neutral, it's all objective. People don't go to a ball game to see the umpire, they go to see the batters, they go to see the catcher, they see the pitcher. He was only going to be neutral. She didn't find it very convincing. She realized that there is judgment involved, even in the work of an umpire. Judgment about the strike zone. One umpire famously described it as a living, breathing document, the way some people like to describe the Supreme Court's Constitution. She was a lot more convinced by what Elena Kagan said during her confirmation hearings, when she said that it's nowhere near that robotic or mechanical, especially in tough and close cases, which are the only ones that reach the court. Judgment is involved. We bring a lot of ourselves to the process of deciding cases. And that's as it should be, Max told her, and she responded. She was very bright. She didn't know a lot of law, but she said, look, if it's not what Roberts claimed he could make it, not just an umpire calling balls and strikes, why isn't it just a matter of unelected judges serving for life, imposing their political preferences on the rest of us? Now, Max is a very loyal research assistant. His reply was, well, read Larry Tribe's book. Good for you, Max. The umpire analogy, he told her, was great PR, and it actually did contain a germ of truth. Namely, good judges, like good umpires, should apply their philosophies consistently. They shouldn't bend them to cut slack for their favored players or teams. to help those that they like bring home the pennant, or to hurt their political adversaries. That much is true. But of course, the umpire analogy is a vast oversimplification. It suggests that personal judgment, personal understanding of what the Constitution is about, what its ambiguous terms mean, what our national history commits us to, have nothing to do with it all. Ambiguous language like liberty, equality, ambiguous principles like what the role of the court should be, how active a role it should play in American life. All of those things don't come down from on high. They're not written in stone. They're not objectively decipherable. And we shouldn't expect justices not to bring their personal philosophies to bear, nor should we always expect to find their philosophies striking us as right or even as neutral when we might be coming from a different worldview. Elections, of course, have consequences, and the selection of justices by a series of increasingly conservative Republican presidents with a certain perspective on the world and on the Constitution is among those consequences. The umpire analogy is off base, pun intended, to the extent that it pretends that the system expects judges to be blank slates, to bring nothing of their views of the world and of the law to the table. So Max did urge his music teacher to read the book. He said it would teach even legal experts some important lessons, but it would also be fun, he said, for her and other non-lawyers. It's filled with great stories about everything from really fascinating cases to the justice's personal obsessions with things like baseball. And one story that he mentioned to her that features in the book was about Justice Potter Stewart's devotion to the Cincinnati Reds, which extended to making sure that his law clerks were watching this small TV that he set up in his chambers while he sat on the bench during the 1973 playoffs between the Mets and the Reds. The clerk knew his boss's priorities, and in mid-argument on some technical preemption case, he sent Stewart a note. Here's what the note said: Kranepool flies to right, Agnew resigns. In that order. My research assistant went on to explain that reading Uncertain Justice, which he hadn't read, he helped me with a couple of footnotes, and it's like, you know, you touch the tail of an elephant, somebody else touches the trunk, someone else touches the underbelly, but nobody has seen the elephant full. So he finally saw the elephant, and he had read it, and he said that reading it taught him that the standard story about the increasing number of 5-4 splits along political and even partisan lines made good press, but it shouldn't really disillusion her because it was a lot more misleading than informative. It turns out that only about a fifth of the cases since Roberts became Chief Justice in 2005 have been divided 5-4. And at least a third of the 5-4 splits involve unlikely bedfellows, like alignments where one of the liberals, like Breyer or Sotomayor or Kagan, joins with Roberts, Kennedy, Thomas, and Alito to create a 5-4 alignment in which the 4 dissenters are the other 3 liberals plus Scalia, who is invariably more protective of privacy rights from the government, and in that sense more liberal than Breyer or pretty much any other justice. You wouldn't know that from the reputation that Scalia has nurtured as a radical, uncompromising conservative. Just yesterday, for example, Elena Kagan led a 5-4 decision that ruled against immigrant children who had the bad luck to turn 21 before their parents, who had green cards, got to the head of the slow-moving waiting line for an immigrant visa. Kagan's opinion was joined by Anthony Kennedy, a Republican, Ruth Ginsburg, a Democrat, And Kagan's conclusion was supported in a separate opinion written by Roberts and joined by Scalia. The dissenting justices who ruled in favor of the boy who had turned 21 after his mom, who had immigrated from El Salvador in 1998, had waited in line for 8 years. But it was his misfortune. He turned 21. He had to go to the end of the line. They were also unlikely bedfellows: Clarence Thomas, Samuel Alito, Stephen Breyer, and Sonia Sotomayor. That was not that atypical. In lots of difficult and divisive cases, you get these unusual alignments. There was a decision that the book deals with in some detail where Kennedy led a 5-3 majority. Kagan was recused, striking down most of Arizona's Show Me Your Papers anti-immigrant law. Scalia wrote a dissent that called the court's decision mind-boggling. He went out of his way and outside the record of the case to attack Obama for something unrelated to the case: his use of executive power to favor the immigrant children known as Dreamers. The Washington Post, which usually selects the president or a senator or a cabinet member for the honor, bestowed on Scalia its Worst Week in Washington prize, partly because he was also outvoted in the Obamacare decision that came down 3 days later. Those are just some examples, and the book deals with them, explains them, gives you a way to understand them. It's not just the unusual alignments in cases decided by sort of a bare majority that expose the fallacy of the increasingly common description of the Roberts Court as a gang of right-wing political hacks in robes. There are plenty of 9-0 rulings, which accounted for nearly half the decisions in 2012 to 13, in which the 9 justices are divided among themselves. It just looks unanimous, but in fact they're pointing in lots of different directions. And if you study the directions, so you don't have to be sort of a legal maven to understand them. You just have to speak plain English and decipher what the court is doing. They divide among themselves in ways that tell us a lot more about what is really going on and where the court is likely to go next than the numbers alone suggest. Among the most intriguing and illuminating divisions within the ranks of the 5 justices appointed by Republican presidents are those between Scalia and Alito. When Alito was nominated for the court, people called him Scalito, thinking that he was just going to be a clone of Nino Scalia. Nothing could be further from the truth. They battle one another furiously about free speech, about privacy, about the need to stick to the original meaning of various parts of the Constitution. For instance, in the oral argument about selling violent interactive video games to kids without the consent of their parents, it looked like Alito was prodding the lawyers about, well, you know, Hansel and Gretel, that's pretty violent. The original Constitution didn't treat violent speech differently. And Alito, losing patience, told one of the lawyers, "I think what Justice Scalia wants to know is what James Madison thought about video games. Did he enjoy them? And what if they were violent? Or what about the opinions involving the government's use of a GPS to track somebody's car for a month without a warrant?" In that case, there was an even more fascinating back and forth in the opinions between Alito and Scalia. Scalia said, you know, there are analogies from the 1790s to this. And Alito basically said, yeah, like what? And Scalia said, well, a constable could hide in a coach for weeks to monitor the owner's movements. And Alito, in his concurring opinion, and this is one where all 9 justices thought that following somebody with a GPS for a month without a warrant was impermissible. Alito wrote, something like this might have occurred in 1791, but it would have required either a gigantic coach, a very tiny constable, or both. Not to mention a constable with incredible fortitude and patience. And that's just the tip of the iceberg. Over and over again, justices who come from the same wing of the ideological spectrum have a different take on the Constitution. They will sometimes agree on the bottom line, but their disagreements tell you a lot about things like the pending case about cell phone privacy and about lots of other cases, where if you just count noses and do arithmetic, you're going to be completely misled. Well, after exploring similar patterns and contradictions on topics like equality, gun rights, states' rights, the book, which people across the spectrum, including Ted Olson, the guy that beat me and David Boies in the Bush v. Gore case, describe as superbly even-handed. Makes me feel good when people across the spectrum say this is a fair treatment of deeply divisive issues. Well, after exploring those patterns and contradictions, the book shows that the court is in the business of undertaking not only some scary, but also some promising and innovative inquiries into how government's powers to coerce and to bribe with offers short of coercion might be limited by the Constitution in areas ranging from Obamacare's individual purchase mandate and its Medicaid mandate to the states, to plea bargaining in criminal cases, to laws that condition federal subsidies on the recipient's agreement to sing the government's tune, even when doing so means undermining the recipient's integrity and its ability to pursue its social mission. Let me just say another word about that example. In a decision that I think is overwhelmingly important, but that got very little attention last year, Roberts, writing for the court, said that the government had no authority to tell non-governmental organizations that were fighting HIV/AIDS around the world that it could get government money to supplement its private resources only if it promised to join the government's anti-prostitution and anti-sex trade campaign. Now, a lot of these characters said, well, if we do that, we won't get the trust of the sex workers. Scalia and Thomas, dissenting from the Roberts opinion striking down that condition, said, too bad, they can just say no, turn down the money. And Roberts says, freedom to turn down the government's offer is not always a sufficient answer when the offer uses government leverage over private resources to get people to sing the government's tune. So the court is moving in lots of intriguing directions that the book deals with. The book identifies powerful trends in various justices' views of coercion and marginalization that connect important aspects of decisions discussed in the book. Like, for example, the 5-4 ruling upholding the core of Obamacare, the 7-2 ruling striking down the Medicaid part of Obamacare, the 5-4 rulings striking down one campaign finance regulation after another. Now, those may not seem like they have a lot to do with each other, but I show in the book that in fact they are born of similar views and they are subject to similar contradictions. And then there are decisions that, of course, I don't discuss in the book that were handed down since it was finished, like the decision in Town of Greece versus Galloway, upholding sectarian town meeting prayers. Terrible decision, in my view, over 4 powerful dissents, the most brilliant of which was probably that of Elena Kagan. Now, maybe I'm biased, she was a student of mine, but that's balanced by the fact that the Chief Justice was a student of mine. And I see a few of my students in the room. So I've had a great time teaching, and that gives me a kind of look into the approaches that various people are likely to take. One of the things about that case that distressed me most was that all 9 justices, including the supposed liberals, went out of their way to say that the Supreme Court had been right 31 years ago when it upheld legislative prayers in Marsh versus Chambers. Now, that's the beginning of difficulty for the separation of church and state. So they were counting angels on the head of a pin when they should have been saying that the pin was rusty to begin with. Anyway, the more I read from the book or give away its insights in advance, the less you will be tempted to read it yourself. But let me just, since this was advertised as a reading from the book, let me read a little bit, a couple of paragraphs from the chapter called Freedom of Speech, Sex, Lies, and Video Games. An area, by the way, where almost all the press about the court is wrong. There are lots of people, distinguished people like Floyd Abrams, who say it's the most speech protective court ever. There are other people like Adam Liptak of the New York Times who say, oh no, what's really going on is that the justices vote for the speakers they agree with and not the other way around. I think the book shows that both of those positions are absolutely untenable. Anyway, let me begin and end with these two paragraphs from the Freedom of Speech chapter and then take your questions. Throughout the late 1960s, the justices of the Supreme Court spent at least a day each year in the basement watching porn together. By all accounts, it was fantastically awkward. Unable to define obscenity, but convinced that the First Amendment couldn't possibly protect unduly dangerous and morally corrupting expression, the court was forced to create constitutional law, one sex scene at a time. The films ranged from scientific documentaries to the improbable escapades of lesbian nymphomaniacs. Justice Thurgood Marshall, a civil rights hero, took merciless pleasure in narrating the clips for the special benefit of Justice John Marshall Harlan II, an elegant former Wall Street lawyer who was by then losing his eyesight. So Marshall would basically say, okay, John, look what's happening now. Look what he's doing. Look what she's doing. Mocking Justice Potter Stewart's insistence that I know it when I see it, clerks would call out in the dark, I see it, I see it. In 1968, about 20 years after serving in the U.S. Navy, a still youthful Stewart reflected on more adventurous times and confided in a particularly curious clerk. You might wonder who that was, but I think you will all guess. That he had indeed seen it. When I said, Mr. Justice, have you seen it? And he said, just once, off the coast of Algiers. And that's all I was ever able to learn about what it was that he saw. Well, that's all I want to say about the book, and I really welcome your questions. Thank you for your attention.
Regarding Justice Marshall, you quoted in page 299 of your book, in 300, that it is the judiciary's role to say what the law is. I assume
That's not Thurgood Marshall. That's John Marshall, Chief Justice Marshall, right?
210 years ago.
Mm-hmm.
Is this still the case? Because my question is about the case very tantalizing about Jerusalem and the question of citizenship.
Yeah.
You quote the case that the court decided that the judiciary has a right to intervene. It took the side of the Congress, which voted to enable the person to claim Israeli citizenship, but you don't give the outcome.
Because the case is still pending.
Oh, it's still pending?
It was in the court twice, just like the case of the woman Carol Ann Bond, who poisoned her best friend, or tried to. It was a botched job. She put all this arsenic compound on doorknobs and other things, but all she did was turn her best friend's fingers red. The question was whether, when she was prosecuted by the U.S. government for violating the law passed to enforce the Chemical Weapons Treaty, which is a little bit odd. This is an Agatha Christie domestic dispute. The question was whether she could challenge Congress's law on the ground that it violated states' rights. And oddly, the Obama administration said, no, she has no standing, even though she's threatened with imprisonment. Supreme Court, I think rightly, unanimously said that's wrong. This is a case where she does have standing, and then the court decided in round 2 this year that Congress had exceeded its authority, or at least that we should interpret its law not to apply this way. Now, in the case you mentioned, which is called Zivotofsky versus Clinton, there was this guy who wanted his place of birth on his passport to be designated Jerusalem. Congress had said,
Designated Israel.
well, he was born in Israel, but he wanted to be designated as citizen of Israel, whose capital, he said, was Jerusalem. That's obviously a politically very volatile issue. The Clinton administration was involved in it, and Barack Obama and his Justice Department took the position that the court had no business resolving anything about this. It was a matter between Congress and the president. If Congress told the president and the State Department what to put on the passport, then let them fight it out. The Supreme Court in the first round said, no, it's our job to say what the law is and whether Congress was invading the president's foreign policy prerogatives. It's our job, and therefore your attempt to keep it away from us is impermissible. And now they've heard argument on a very difficult question. On the one hand, Congress does have the power to impose constraints on the president, just as it has tried to do with respect to the exchange of Guantanamo prisoners, saying, you've got to give us 30 days notice. President, in that case and in the case about Israel and Jerusalem, has said, it's none of your damn business how I conduct both my job as commander-in-chief. It sounds very much like George W. Bush. It's not your business how I conduct my job as commander-in-chief or how I instruct my Secretary of State to conduct foreign policy, whether it's Hillary Clinton or John Kerry. And the Supreme Court is not buying it, and the question now will be, how do you strike the balance between Congress's authority to draw the limits and the president's authority to make the final call? And I don't really have a clear prediction.
Will you belong, perhaps? If you were Supreme Court, what opinion would you write on the case?
Well, one of the advantages, there aren't many, but one of the advantages of never having been named to the Supreme Court is I don't have to do that. I don't have to decide. I can be an academic and I can help people figure out what they think, which is what this book is designed to do. It's not designed to preach either to my liberal friends or to my conservative adversaries. It's designed to talk to both sides and help them talk to one another. So if you think I'm ducking, you're right. Yes.
In 2000, during the 2000 election, the Boston Globe reported that the press was curiously indifferent to the prospect of whom George W. Bush would nominate for a Supreme Court justice. Do you see this as an ongoing concern in ensuing elections, whether people are on the right or the left?
Well, I think it's an enormously important concern because the choice of presidents determines a lot of things, including the choice of justices. And even though a president can't always get his or perhaps someday her way, as we saw when Reagan nominated Bork and Bork was soundly defeated, nonetheless, the president carries huge weight, as does the selection of the Senate. But people are so much more concerned with the cost of living, with whether they can get a job, with whom they can marry, with a lot of things that in the end the Supreme Court will have a lot to say about. And so far, most people have put the impact of their vote on the selection of justices on a back burner low on the list of issues. One of my indirect objectives in this book is to gradually nudge people toward paying a lot more attention to that. I don't do it by buying into the idea that it's all politics, but I do try to show how the way justices look at the world makes all the difference. Take, for example, racial issues and affirmative action. In that area, the court is deeply divided. There are 4 justices who have the strong view that the country has pretty much gotten where it needs to go on issues of race. So that the Chief Justice says the way to stop race discrimination is to stop discriminating on the basis of race. Simple. Let's not pay attention to race. The problem will take care of itself. There are 4 other justices who think that's profoundly misguided, who think that any nation with as deeply problematic a racial history as ours can't simply, like an ostrich, put its head in the sand and hope the problem will sweep itself away. Justice Kennedy is sort of in the middle on that issue. And he's often criticized for being indecisive, but I think, in fact, he sees that there is something to be said for each point of view. And in particular, I know that probably, given the demographics, not many people in this room are fans of Clarence Thomas. But the fact is that the deep debate between Clarence Thomas and Sonia Sotomayor about affirmative action is incredibly informative. They both recognize that they have been the beneficiaries of race-sensitive decision-making by universities and to some extent by government. They come out very differently as to what they think about that. Thomas says, "It's made me feel inferior all my life. Everywhere I go, people say, he's an affirmative action baby. He's there only because he's black. I feel excluded." Sotomayor says, "I understand that, but I feel very differently. I know that I wouldn't be where I am today but for the benefits of affirmative action. I don't want anyone else to be denied that opportunity. It doesn't undermine my sense of self. My ego is intact." Now, when you look at that, you can say, well, what does that personal experience have to do with the Constitution, written on parchment in the National Archives under glass? It has everything to do with it. What does it mean to deny people the equal protection of the laws? That's a concept that you can't define algorithmically, mathematically, through some robotic computer program. You have to give it meaning, and the only way to give it meaning is in terms of your life. And some justices are a lot better than others at being open and candid about what it is in their own experience that brings them to the place where they are. I tend to appreciate that candor. I think that the people of the United States are smart enough not to equate it with the idea that these judges are not really being judicious. Well, the question is whether the Supreme Court's dismantling of campaign finance reform and its rejection of essentially every congressional effort that now comes before it to limit the influence of wealth and of corporate power, but also of unions on elections, whether that set of decisions, which do tend to split in partisan ways, are, whether that's somehow a refutation of my view that these people are trying their best to give vent to their beliefs about the Constitution. I don't really think so. I mean, you can agree or disagree with Citizens United, but the fundamental philosophy of the majority in those cases is not, contrary to what lots of people seem to think, that corporations are just human beings in drag, or that money is speech. They're not saying that. They're saying that we don't trust the government to decide what speakers should be heard and how much money various interests should spend on speech. As it happened, Citizens United was an anti-Hillary Clinton documentary. But if it had been an anti-Romney documentary or an anti-McCain documentary, that suspicion of government playing the role of kind of orchestrating the playing field for speech would have been exactly the same. Another way to look at it is that however much we may worry, and I do a great deal, about the injury to representative democracy of having great wealth play so huge a role, we may be less than confident that the solution to that problem is to take the very people that we believe were paid and bought for, bought and paid for, sorry. The very people who were bought and paid for in positions of power, and hand them a blank check, say, here, you write out a scheme for campaign finance reform. And by the way, don't gimmick it up so that it will reassure your reelection. Don't favor incumbents, something that the court is not able very well to police. Giving that power to the very people that we are afraid are too influenced by money, by reversing the Supreme Court's understanding of the First Amendment, doesn't look like much of a solution to me. So that's one of the most serious paradoxes that confront us, the paradox of speech and money and power. Well, I tried to help Adam Schiff and a few members of the House and of the Senate. Adam is a Democratic congressman from California who was once a student of mine, to draft an amendment. On the premise that an amendment would be a good idea, I tried to help write it in the best way possible. But what I ended up with isn't something that I myself could particularly support, because all it would do is give these guys who, frankly, got there as a result of financial influence as well as everything else, the power to write their own ticket for re-election. The amendments that people have proposed are, many of them are just, to be candid, ridiculous. Saying corporations are not people, that's one of them. What good would that do? The First Amendment doesn't protect only certain speakers, it protects speech and listeners. So that if E.T. were suddenly to walk into the Harvard bookstore, and E.T., I think, is not a person, and if E.T. started speaking and the mayor of Cambridge and the city council of Cambridge said, we don't want E.T., who doesn't even get to vote, to have a lot of influence in Cambridge. We're going to gag E.T. or prevent E.T. from spending money circulating E.T.'s views. That would violate the First Amendment. And saying E.T. is not a person wouldn't help. So, constitutional amendment, I mean, I don't want to leave people with a kind of despairing feeling. And on Citizens United, I don't really know how to work my way out of that box. I think if you read the treatment, you'll say, well, God, at least I understand a little more where they were coming from. It doesn't seem so crazy, and some of the simple solutions don't seem so workable. And just, you know, knowledge is power. Being able to understand why you shouldn't let people pull the wool over your eyes and say, here is a simple solution, I think should make you feel a bit better. At least it makes me feel better. But then I'm an academic, and to some extent, that's a strange breed. Yes?
But were you surprised at Roberts' vote in Obamacare?
No, in fact, not only was I not surprised, but I went on television on MSNBC and elsewhere, both before the oral argument and after, saying Roberts would cast the decisive vote to uphold the individual purchase mandate on the basis of the taxing power, not the commerce power, because I knew that Roberts' basic views are quite libertarian. He thinks taxes are not as coercive. Coercion is a big theme. Taxes aren't as coercive as direct regulation, because if the government has the power to make you buy insurance, it could throw you in jail for not doing it. Here, all they're doing is raising your taxes a bit, and not to a degree that actually makes you do it. In fact, the tax add-on that you have to pay if you don't buy the insurance is typically less dollars than the insurance premium would be. So I made those statements. Rush Limbaugh then said, this guy should be committed. He's crazy. There's no way that Roberts will vote that way, especially on the basis of the taxing power. So I wasn't surprised. I was a little surprised that Kagan and Breyer joined Roberts, Scalia, Alito, and Thomas to make a 7-2 decision striking down Congress's rule that those states that don't accept the broadened Medicaid program, which is almost entirely paid for by the federal government, would lose all their Medicaid dollars. That was quite a departure from their liberal colleagues, like Sotomayor. I was a little surprised. I have a theory in the book about why they did it. I think one of the reasons they did it is they thought, you know, since Roberts is doing a moderate thing and upholding the purchase mandate, we can go along with him on this. And it won't make much difference, because they mistakenly believed that essentially every state would go along. They didn't realize how many states would say no, ideologically based no, hurting their own people severely and undermining how workable Obamacare would be. I think they also got some benefits from the way they voted. That is, they prevented Roberts from going further still and holding that you can't use money to influence, federal money to influence state decisions. That would have been an even more radical decision, and it was possible. But by offering to join him on the basis that this was like a gun to the head of every state, because it would hurt them so much to pay the penalty of getting rid of all of Medicaid. By going along, they essentially prevented it from being more drastic. He had 5 votes anyway, but they enabled him to get 7. Yes?
You partially answered something that was on my mind as you talked. That to a layperson, when you see the 5-4 on one part of the Obamacare and the 7-2 on the other, it looks like horse trading. And I'm just curious to what degree you see horse trading as being a common part of the decision making.
Well, I don't think it was straight out horse trading, because the Chief Justice already had 5 votes to strike down the Medicaid mandate. He didn't need the other 2. It's always nicer to be the author of a 7-2 decision, but I don't think he needed those votes. If he had needed them, then that would be more plausible. But there are really very few cases in which justices seem to do that, partly because they care not only about the bottom line in this case, they care about their legacy. They know that they are laying down a precedent. The Supreme Court is the only branch of our national government that has an obligation, not imposed by the Constitution, but imposed by tradition, of writing opinions in which each justice, either by saying something or joining an opinion or joining a dissent, explains what he or she is reasoning that leads them to that conclusion. No other branch does that. You know, members of Congress can vote and then go home. The president can take action or not action, and it's up to him how much to say to the people. And because they have to rationalize their opinions and then live with them for all these years. I mean, people like Alito and Roberts are still young, Elena Kagan younger still. They don't want to lay down a landmine that will then blow up under their feet. Yes?
How will the court and the government in general deal with discrepancies between state law and federal law? So, as an example, the legalization that's recently happened. It seems like not enforcing federal law is not a long-term solution.
Well, it's not a long-term solution, but right now with a paralyzed Congress, it may be the best thing that's available. It's not quite a matter of not enforcing federal law. It's a matter of prioritizing some enforcement over others, deporting people who have serious criminal records, rather than people who have been here, have abided by the rules, have abided by the law, who came here innocently when they were children, who were brought here by their parents, deciding not to deport them until you get to the end of the line, and that's going to be decades away, I think was within the president's prerogatives. It may not be a long-term solution, but it's better than a sort of a totally brutal exercise of mechanical power. Yeah.
I know that not long ago, Justice Kennedy wrote the decision striking down DOMA, and on a naive reading of it, it seemed like the decision was bigger than it could have been. It seemed like he was doing some serious work there. Is there anything interesting that we should note about that?
Yeah, I think that one of the possibilities in the Defense of Marriage Act, which basically said that even if you are a married couple in a state that allows same-sex couples to marry, the federal government, which usually defers to the state definitions of family relationships, will treat you as unmarried, and you'll lose tax benefits, Social Security benefits, about 1,000 different things you'll lose. When the Supreme Court struck that down, it was by no means clear it would. It was quite clear that 4 justices, the 4 nominated by Democrats, would regard that law as completely inconsistent with principles of liberty and equality and dignity. They weren't particularly enamored of states' rights. The fact that the federal government was interfering with state prerogatives in an indirect way wouldn't have bothered them alone very much. And in fact, they would have been rather troubled to join an opinion that rested entirely on that rationale, because that could come back to bite them. Because if it's not up to any federal institution to decide whether same-sex couples can marry or not, then when it comes to the ultimate challenge, when some states say, well, we want to ban same-sex marriage here, the federal government might be powerless to intervene. What was unclear was where Kennedy would go and on what ground. One possibility, since Kennedy is a very strong advocate of states' rights, is that he would invalidate DOMA solely on the basis that the feds had no business telling the states that people that they think are legitimately married are unmarried for federal purposes. That would be purely a federalism decision. But what I think you're referring to is that he went further than that. He said that once the states, let's say the state of Massachusetts has said that Bill and John are legally married, or that Nancy and Linda are legally married, for the federal government to say anything other than that is to insult their dignity. There's no possible rationale for that other than to say that they are second-class citizens, that their union does not count as much as that of other people. That's what Kennedy said. He used federal-state relations as a hook, but then he swung all the way across the stage and made everything turn on liberty, equality, and dignity, which is why every lower court case since that decision in Windsor has said that regardless of any federal-state element, when a state decides that two people cannot marry, even though they're otherwise eligible, and even though they love each other and want to form a permanent relationship just because they are of the same sex, every lower court has now said we can't rationalize, we can't understand the Windsor opinion if we don't go all the way here. And in fact, Scalia did everybody a favor in his dramatic dissent, saying, now that you've said this, you're bound to take the next step, and that's going to come back to bite him. Well, the question was, if I had an opportunity to rewrite one of the amendments, which would it be? Before I answer that question, I want to tell you that when I wrote my treatise, I had a publisher who sent me the final galley and who said, if you have any changes in the Constitution you'd like to make, this is the time to make them. I think what he meant is, if you have any corrections in your text, this is the time to make them. You know, I think the Second Amendment, though it's not something of which I'm a great fan, because I'm not myself a believer in the importance of guns as a way of protecting safety. I think they endanger people more than they protect them. Second Amendment is not among my favorites, but there it is in the Constitution. Didn't shock me that the court gave it more muscle. And if we were to get rid of it, as Justice Stevens proposes we do, the idea that all of a sudden we would have universal registration, all kinds of safety requirements, you have to, you know, severe restrictions on gun ownership, that's a fantasy. The thing that prevents powerful restrictions on gun ownership in this country is not the Second Amendment, but the First. The ability of the National Rifle Association and others to exert powerful influence, and the fact that for many people in this country, like it or not, this is a voting issue when they are on the pro-gun side, but it's not so much a voting issue when they are on the pro-gun safety side. So getting rid of the Second Amendment would have very little, I think, positive effect in terms of those who favor stronger efforts to secure gun safety and to reduce the carnage. But it would have lots of negative effects. That is, a lot of people would say, now that you've gotten rid of the Second Amendment, we've got some stuff we'd like to do to the First, you know, and maybe the Fourth, and maybe the Fifth and the Sixth. One of the reasons that it's so dangerous to tinker with the Bill of Rights, and this goes also to your question of an amendment to get rid of Citizens United by changing the understanding of the First Amendment, is that once you start, it's hard to know where you're going to stop. It's like spelling Mississippi. I sort of know how to spell it, but I don't know how far to go and how long to go on. Well, I think the Constitution as a whole manifests lots of distrust of the people, distrust of the masses, that they would somehow cancel all their debts and injure the stability of the financial system. People like Alexander Hamilton were deeply concerned about that. The Marshall Court, though many people regard what it did in 1803, 1805, Marbury v. Madison and the like as quite radical, really moved rather cautiously. That is, even though it invalidated one narrow provision of the Judiciary Act of 1789 in Marbury, the next time the court invalidated any part of an act of Congress was 1857 in the rather infamous, justly infamous case of Dred Scott v. Sanford. So the court was really keeping a sword of Damocles over the political branches. getting them to take their oath more seriously by threatening that if they didn't, it might come down upon them. But it wasn't really exercising that power with the kind of frequency or vigor that it has in years since. Then in the period in the 1890s to 1937, the court really went quite wild, striking down all kinds of socioeconomic regulation. There was a constitutional revolution at that point, not because of court packing, but because of death. A lot of the old members of the court died. FDR had a chance to replace them. We got a court that was much more deferential to politics, except for certain areas where there has been, since the 1940s, a pervasive distrust of majorities, of the people, if you will, that they would gang up on minorities, racial and gender and other minorities, and that they would not treat fundamental rights seriously. What we've done in the end is strike a balance in which there are some areas where the court is more active, others less. And it would be sort of a long process to engage in the full debate over whether the court has struck the balance right. The current court is moving again, rather frighteningly to some people, in the direction of reviewing laws that affect the economy in a serious way. For example, laws that were passed in Vermont to make it harder for pharmaceutical companies to jack up the drugs by getting information about drugs to certain doctors so that they would prescribe more costly drugs. The court struck that down on the basis of the First Amendment. Sotomayor joined the conservatives in that, and Breyer went almost apoplectic. I mean, he said this is a return of what was called the Lochner era, that period from the 1890s to 1937, when the court was striking down economic regulation rather loosely. Because if you strike down an economic regulation simply because it deals with speech in one way or another, it deals with information. Information in our society is at the heart of almost everything. And using the First Amendment that way could give the court the kind of power that I think is presupposed in your question. Some people think that's exactly what was right, because the ability of government to interfere in our economic lives is incompatible with the premises of liberty. Other people think that meaningful liberty requires government interference and a safety net. But I think this court, if it had one or two more people like Roberts, Alito, Scalia, Thomas, might go rather dangerously in the direction that in 1937 we abandoned.
We have time for 2 more questions.
Yes.
You just mentioned that information in our society is crucial and critical. What's your view of some of the Supreme Court justices who have changed the wording of some of their opinions after their opinions are issued? Mm-hmm. You being an academic, I'm sure study every opinion to see which way.
Oh yeah, and I've found some real doozies. It does bother me, but what happens is that and it's not just part of the current insatiable, instantaneous news cycle, but there's been a lot of demand from decades ago to know exactly what the court decided the very moment it decided it. So the printing office of the court, as it used to be, I don't know, now they may have something a little bit more fancy. The printing office used to come out with what were called slip opinions within minutes of the decision. And because they were produced so quickly, there often was a slip in the slip opinion, and it would sometimes reveal something that the justices thought their latest draft had fixed. I mean, one thing that I noticed when the Supreme Court in 1992 reaffirmed the core of Roe versus Wade in a case called Planned Parenthood of Pennsylvania against Casey, if you carefully read the Rehnquist dissent, you can tell from the very first slip opinion that it was a majority opinion. It was going to be a majority opinion overruling Roe versus Wade. But that got patched up when Kennedy, Souter, and O'Connor, as a group, decided that it was important for stability of the society and for the equal status of women that Roe v. Wade not be overruled. They patched it up, and so a lot of students, turns out none of my colleagues teaching constitutional law anywhere in the country seems to have known that. I thought everyone knew it. But people study this decision as though it was sort of foreordained that the court would not get rid of Roe v. Wade, but it came within inches of doing exactly that. How to solve that problem, I'm not really certain. I mean, you could make the country wait before the court announces an opinion, but that's rather difficult, especially when the whole country is hanging by its fingernails on a case like Obamacare or some other case. So you announce it and then you sort of clean up the opinion. But I think there should be much more sort of journalistic integrity about the way, and academic integrity about not making changes sort of sub rosa. I think if the court is going to make a change that actually changes the meaning of what it initially announced, it should have an obligation to make that clear with some kind of errata sheet or supplement. Yes?
This will be our last question.
Yeah, that will be the last question.
Thank you, Professor, for your book, for your presentation, for all your work. As a lay person and ignorant, I was shocked, most of all, for the freedom of speech interpretation of the court when they uphold the Citizens United. And I believe that all the criticism that I've heard here about the individual judges raise a more profound question, and that is that as the American democracy is turning into a plutocracy, is the court a reflection of that kind of change?
Well, some think it's a partial cause of that kind of change. Others think it's a reflection. I think it's more complicated ultimately than that, because the reason the court rules as it does in Citizens United is not a belief that corporate power and wealth should dominate our society, but a belief that government cannot be trusted to decide whose voices should carry weight. It's an anti-government decision, much more than a pro-corporation or a plutocratic decision. It's in that way somewhere between anarchy and libertarianism. It's a mistrust of government. Similarly, many of the court's decisions making it easier for businesses to prevail over individuals reflect, as I try to show in the book, not so much a bias in favor of big business as a mistrust of litigation and of the trial process as a way of solving problems. When you focus on what it is that drives the justices, motivates them, that may give us a better idea of what kinds of questions to ask and what kinds of things to look for in the backgrounds of the next set of justices who will come along when some of those who are aging out, as it were, leave the court. I think it is much more the mistrust of government than trust of corporate power. In fact, the court has said you can make corporations disclose fully all of their contributions online and instantaneously. You can reform the structure of corporations to make it easier for shareholders to hold them to account. You can do all kinds of things to corporations. And as some of the justices pointed out in Citizens United, it is in fact the mom and pop corporation, the tiny corporation, the subchapter S, the closely held corporation, not the giant publicly traded corporation, that benefits from decisions like Citizens United. So the story is a lot more intricate and complicated than simply plutocracy.